way, the most awkward part of getting a divorce, or really having any sort of family case that involves children, is the financial disclosure portion of the case. And I understand that this creates a lot of anxiety for people. You've got to go through, a year of your credit card statements, a year of your checking accounts. You got to give that information to the other side. And in Florida, we have mandatory financial disclosure. Anytime you get a divorce, you've got to disclose all of your finances. A lot of people these days, even though they're married, they don't have joint credit cards. They have private credit cards. They have their own checking accounts. And they get stressed out when they learn that in a divorce that they're going to have to give a year of their statements to their other spouse. Not saying that there's necessarily anything wrong, certainly nothing incriminating in the bank records, but your spouse is going to have an opportunity to comb through every dollar you've spent on a credit card or a checking account for the last year. And that can be a very awkward and stressful feeling. However, like I said, it's mandatory in Florida. There are a few exceptions. If you get a simplified divorce in Florida, you can waive financial disclosure. You'll still have to file a financial affidavit, which, any divorce lawyer, especially our office, we work with you to help you develop that financial affidavit and make sure it's accurate. But you can, under certain situations, waive financial disclosure, meaning not having to actually provide your spouse with those bank statements and those credit card statements. At the outset of every case that we handle, we look for opportunities to waive financial disclosure. Can't do it in every case, and certainly in the majority of cases, we're not allowed to do it, and it's always subject to a judge's approval. However, we try to waive mandatory disclosure. For some people, it might be more awkward. For others, they don't care. They've got nothing to hide, and that's great. Either way, we like to hold our clients' hands through the process and try to make it as painless as possible. If you have a paternity case or a modification case and you have children, it is still possible to waive financial disclosure. However, you still have to provide that financial affidavit. There is no way around that. You see, in simplified divorces, we can, under certain situations, get away with not even filing a financial affidavit if the parties agree on every single aspect of the divorce. However, if they have children, they cannot waive the financial affidavit. At a minimum, that must be filed by both parties. Financial disclosure is due 45 days after service of the initial petition. So it's a good thing to start working on early on in the case. And if you're contemplating filing for divorce or a modification action or establishing parental rights through paternity, beginning to gather those documents that you'll need in financial disclosure can be helpful, and it can also save you money when you do hire a family law attorney. The less we have to do, the more you save. At the beginning of any case that we have, we will provide our clients with a list of the types of documents that they need to produce. We also have an assistant in our office who does nothing other than help with financial disclosure. And we work with the clients hand in hand to tell them exactly what documents they need to provide. We make sure that we get all of those documents, we analyze them, we categorize them, and we prepare them for disclosure to the other party. If you have any questions about equitable distribution or any concerns, feel free to reach out to our office. We're happy to help. We service the entire state of Florida for divorces, paternity cases, and modification cases.